Hi, and welcome to the update on the Colorado Local Rules and Bankruptcy Forms effective December 1st, 2017. I'm Tara Salinas. I was a member of the Local Rules Standing Committee that helped to put these rules together, and I'm here to help you understand what the changes are and how they'll impact your practice. I thank you for joining me, and hopefully this will be a productive session. There are a couple of general rule changes that I want to make you aware of. First, the federal rules changed with regard to the Chapter 13 plan and now require that each district either select to use the national form plan or create a local plan that is consistent with the federal rules. Our district, as many others have done, have chosen to keep our local plan and make the necessary updates and changes in order to make it compliant with the federal rules. We'll talk a little bit more about the Chapter 13 rule changes and the changes to the Chapter 13 plan form in just a few minutes. The other major federal rule change has to do with proofs of claim. The first is huge, and it's that the federal rules now require all creditors, secured and unsecured, to file a claim in order to be paid. This is critical to your clients in Chapter 13 cases because if the secured creditor fails to file a proof of claim, they will not be paid through the plan. Let me repeat that. If your creditors in a Chapter 13 case on mortgages, car loans, or any other secured debts fail to file a proof of claim, the trustee cannot make distributions to that creditor. It's even more critical at this point that we check the proofs of claim deadlines and ensure that the appropriate secured creditor claims are filed. I also always like to check to see if other creditor claims are filed, specifically priority claims like the IRS and Department of Revenue, child support claims if they're to be paid through the Chapter 13 plan, and also student loans if they're going to share in distribution with Class 4 creditors. The other change with regard to proofs of claim is the change in the claim deadline. The new claim deadline is 70 days from the date of the filing of the case. We are no longer basing proof of claim deadlines on 341 meeting dates. It will always be 70 days from the date of filing. The only exception to this rule is that secured creditors have the opportunity to supply what we call supplemental documentation up to 120 days after the case is filed. In these situations, those are usually things like the mortgage, the note, the allonges to the mortgage or promissory notes. Everything else has to be filed at the 70-day deadline. That includes escrow analysis, if applicable, amounts of arrears, total amount due on the debt. So all of those claims are due within 70 days. Remember that debtors and the trustee have the opportunity to file claims on behalf of creditors after that claims deadline has happened. So I would calendar 71 days after the case is filed as a tickler in your system to check to see whether proofs of claim have come in. It's also a chance, if you're doing a 100% plan, to see whether you've satisfied those claims or you need to amend your plan. Given the time frame for confirmation, it's very likely that by the time you file the first amended plan, if any, or very close to the time of verification of confirmation will be filed, you will be very close to your claims deadline. This makes the process much more efficient than it used to be and allows you to be very effective in handling these cases. Couple general overview information about some changes in the local rules. The first, and I love this change, is that every deadline is calculated based on calendar days, not based on court days or business days. So you've got quite a bit of consistency in being able to count when things are due. The changes have reduced the size of our rules, forms, and the appendice significantly. The old rules covered 238 pages for rules, forms, and the appendix. In the new rules, the appendix has been eliminated completely, and the rules span 87 pages, 68 pages for rules, 87 pages for forms. And there's a new practice guide which runs 29 pages. That's intended to be a replacement for the former appendix. That's a total of 184 pages, a reduction of about 55 pages of information. If you haven't looked at the new local rules and forms yet, I highly encourage you to do that. I think most of us have at least taken a peek. One thing that most practitioners may not be aware of, because it's hidden a little bit, is this e-filing practice guide. This has been put together by the court to help address some of the issues that were previously provided for in either the commentary or the appendix in the rules. Things that are covered here include PACER training, making copies of documents, e-filing policies and procedures, how to file certain types of documents, how to handle motions, some adversary proceeding tips and tricks, and how to correct social security numbers in the event that they're incorrect. I think this is actually a packet that has a lot of really good information. You can find it under the e-filing section of the court's website, and I would definitely recommend you download and take a look at this 29-page practice guide. References throughout the rules have also now been made to specific sections. We've eliminated the use of above and below just to make it a lot easier to find what it is being referenced and to be able to read through the rules in an electronic format. It just makes it a little bit easier than when it's on the printed page. I'm going to go through the rules in somewhat of their order, trying to address the major changes that affect a consumer practice. There are going to be some sections that I think are valuable to look at, but that really aren't that applicable to most people's practice, specifically some litigation issues, some other items like that I want to make you aware of, but that I'm not going to cover in detail. I will do my best to point out changes that may be lurking in the rules as a trap for the uninformed. Let's get started. I've just put all of my rules and forms into a book so that it's easy to see, and I'll go through those as we go. We're just going to start here on page 1 with Rule 1001-1. The only thing that's important about Rule 1001.1 is that it really does talk about the effective date of these rules, which is pretty easy, December 1st. But I think it's important to check out subsection F. And subsection F says, further, these rules will govern all bankruptcy cases or adversary proceedings commenced on or after December 1st, and all pending cases and proceedings insofar as it's just and practicable. Basically, what the judges have said with regard to application of these new rules is that it applies in all cases. The only time that it's not going to apply would be, for example, there are significant changes to the rules regarding sale of property. If a motion for sale of property were pending on December 1st, there's no requirement that that trustee or attorney go back and amend that motion to sell to fit the new procedures. So if you had a no-look fee application that you filed on November 30th, you don't have an obligation to try to change the plan. If a plan entered and sometime between the time it entered and the 28 days when you needed to file a new fee application happens and you're looking to apply for the no-look fee, use the old forms. But that's such a short window of time. So even if your plan got approved on November 30th, didn't have that information in it, or you've got a plan where the objection deadline's coming up, I mean, we're really, again, looking at about a 28-day window, and you are looking for the no-look fee, but your plan didn't contain that provision, which is brand new, effective December 1st, just file the old no-look fee application on those cases, and you'll be able to get that compensation. Let's move on to Rule 1006-1. This is about the installment payments or filing fee waivers. The only point that I would make here is that there is a good list under letter B of what needs to be attached to a request to either waive or pay in installments. We have done away with the GPO that required an additional form. So if you're filing a fee waiver or installment fee agreement, you need to look at 1006-1 to be sure you've got the right information. Another fairly minor change that hopefully none of us need that often is Rule 1007-5, and that's about amending a statement of social security number. You know, every once in a while we have a client who gives us an incorrect number. We review it at filing, at the signing conference. Yep, that looks great. And then you find out that it's not correct. No problem. You can amend the statement of Social Security number. Again, remember that document needs to be filed under seal with the court. The only change here under 1007.5 is at the end of subsection B. That indicates that service needs to be made not only on the trustee and all creditors, but also the credit reporting agencies, Experian, TransUnion, and Equifax. I mentioned the e-filing practice guide. At the very back of the practice guide, the court clerk has included the addresses for those three agencies. It's on page 27. And so if you're curious as to what address you should send to for them, the court has provided addresses that they believe are correct for notice purposes. We have changed Rule 1009-1 with regard to amendments of voluntary petitions, lists, statements, and schedules. There is a new form, Local Bankruptcy Form 1009-1.1, that needs to be attached to every single amendment. I think it's important to note that subsection A of 1009-1 says that amended petition lists, schedules, or statements will supersede the prior filing and may not merely state new or changed items. I know we mentioned this recently on the listserv, but you always have to file a complete schedule, not just a schedule of the changes. That hasn't been clearly delineated before, but now it is. Subsection B talks about the new local form, which needs to be filed with each of the amendments. This is intended to make it easy to identify what has changed because you are filing the whole schedule. So it's intended to be kind of a shorthand for the clerk, for the court, and for the creditors as to what is different in this schedule. Next up is the Local Bankruptcy Rule 2002-1. The main difference here is really with regard to how to do this notice to creditors. There is a new form. It's actually titled Form 9013-1.1. It includes two sections. One is the 9013 notices, and the second is a 2002 notice. And there's instructions at the top of that form that indicate, complete the section that's applicable and delete the rest. So if you're filing a 9013 notice, you're going to use the top section. If you're filing a 2002 notice, you're going to file with just the bottom section completed and delete the 9013 and vice versa. So when you're looking for your certificate of service, that's the appropriate certificate of service to file. I think the important thing is that a note put on that form indicates that you are pulling the creditor matrix as of X date. The court included in the rule under subsection B a statement that movement must use at a minimum all of the addresses contained on the quote most current version of the creditor address mailing matrix. So if you have a matrix that you pull at the beginning of the case, remember there's a date and time on all of those as to when they were downloaded. So be sure that you're pulling a new matrix every time you file a certificate of service. We're going to move on through a couple more of these rules here. Quite a few, easy to get through some of these. Next up is 2016-3, compensation of Chapter 13 attorneys. This is one of the sections I think that may be most beneficial. I certainly think it saves the most time for anyone who practices in the 13 arena if you're filing a no-look fee app. If you've currently been using the no-look fee or the reasonably presumptive fee, which is how the court has designated it throughout these rules, the reasonably presumptive fee can now be entered as part of the confirmation order. No additional forms to fill out, no additional notices to send. Everything can be done as part of the confirmation process. Now, I've always been an advocate of long-form fee apps, but this is really intended because about 85% of the Chapter 13 practitioners in our district use the no-look fee, and if you are using that, it's a great way to reduce your time and expenses. 2016-3 indicates that the reasonably presumptive fee can be included as part of the Chapter 13 plan. It's just a checkbox where you indicate that you are asking for the reasonably presumptive fee. Pretty easy, nothing crazy or complicated there. Just remember that if the case starts getting complicated and you decide in an amended plan to uncheck that box and go forward with a long form fee app, that's not a problem at all. You can make that designation anytime. You'll just need to give notice to all creditors on that. I think the one thing that's important to note is that you're not limited to that presumptively reasonable fee within the plan. Right now, the reasonably presumptive fee is $4,100. That's inclusive of all attorney costs. Again, something that has come up in the past in our discussions is what constitute costs. In the way that this presumptively reasonable fee was created, costs do not include filing fees or fees paid to third-party vendors if you're receiving those from the client. So if you have your fee agreement set up that the client pays you your attorney fee plus costs, say the filing fee, the credit counseling fee, a credit report fee, whatever it is, a comparative market analysis, you can split those out as costs that are not to be reimbursed under the plan. Really, the idea is that your costs up to $200 can be included here without needing anything extra. So $4,100 includes up to $200 worth of costs. If you don't have $200 in costs and you only have $50 in costs, you still get $4,100. It doesn't matter. But I like what 2016-3A5 says. It says post-confirmation fees. Election of the presumptively reasonable fee or any lesser fee does not preclude an attorney from filing a supplemental fee application, which is designated later in this rule, for post-confirmation work. Electing the presumptively reasonable fee does not preclude an attorney from providing for a larger attorney fee amount in the plan. So assume that you're going to be filing Chapter 13 plan. You know, we all know things come up post-confirmation. Motions for relief from stay, motions to dismiss, modifications of plans. Sometimes it makes sense to put a little extra in your attorney fee budget to cover those types of expenses. What this is saying is you can elect the presumptively reasonable fee, but designate in the plan a higher attorney fee reserve. So say you put $5,000 in the plan, $4,100 is your presumptively reasonable fee. That leaves you $900 cushion to do additional work and apply for it through the supplemental fee app procedure without having to modify the plan. That can come in really handy, so it's just something I want to point out to folks. The service on long form fee applications has changed. You always have to serve the debtor, the trustee, any parties requesting notice. If the deadline for proofs of claim has not passed, which I can't imagine a scenario in which you would be filing a fee application, a long form fee application in a case where the claim deadline hasn't passed. But it's possible. If it's before the claim deadline is passed, you have to serve all creditors. If the claims deadline has passed, you only have to serve the trustee, notice parties, the debtor, and claimants, folks who have actually filed a claim in the case. Hopefully that will help to reduce the costs as well. The deadline for long-form fee applications is still 28 days after confirmation. There is a nice couple pieces in the commentary that talk about the presumptively reasonable fee and indicates that the prohibitions against and restrictions on limited representation, which are contained in 9010-1, we'll talk about that later, require that the engagement does not terminate on plan confirmation. So any of you who have been terminating your representation of clients, especially if it's in your fee agreement that your relationship terminates, you'll want to make some changes to those. The representation must last through either the entry of discharge, conversion or dismissal of the case, or withdrawal of the attorney under 9010-4. So you're in it until you're out is basically the new rule with regard to that, and we'll go into a lot more detail when we get to 9010. The court does talk about the fact that in the commentary that if you elect a presumptively reasonable fee, you can come back and file a supplemental fee application. So if you do significant post-confirmation work, you can definitely file a new fee app for that. It indicates in the comments, for example, in most cases, routine post-confirmation services will include reviewing claims after the expiration of the claims deadline, advising on the requirement that the debtor complete a financial management class, communicating with the debtors, creditors, and other parties in interest concerning the case, defending a motion for relief from stay or a motion to dismiss. I actually take issue with that. I don't think that that's something that we would expect is going to happen in a Chapter 13 case. I would certainly expect that that is something you could get a supplemental fiat passed for. And then the last thing is completing the debtor's certification for discharge. So for anyone who's thinking about, doing the presumptively reasonable fee and then charging separately for that, you may want to make sure that there's enough in there to cover that. The court seems to think that it's part of the basic service. We'll keep moving along. We've got a lot of Chapter 11 stuff. We're just going to flip through that because I don't know many of us who do Chapter 11 work. Let's get on to 2083-1. Steve pointed this out at the CLE on Friday, and I think it's a great point. There's an inclusion here under subsection B that talks about calculation of adequate protection. The rule in our district has always been 1% of the outstanding balance due, but there's a nice little caveat here that says unless otherwise ordered by the court. And again, I thank Steve Birkin for pointing this out because I think it's a good point. If you've got adequate protection on a really high balance and you're doing a significant cram down, his suggestion was calculate what the depreciation is on that asset and pay that instead. If the court approves it, then you're in good shape on that. So I think it's a good way to kind of get around those. 3004-1, it talks about filing proofs of claim. I talked earlier about how important it would be to file a claim for a secured creditor if they fail to do so in the 70-day deadline. You've got 30 days after the claims deadline passes to file claims on behalf of the debtor. If the debtor or the trustee, which I don't expect our trustees to be filing claims at all, but it's possible, files the claim, they do have to file, there's a new local bankruptcy form, it's 3004-1.1, that's just notice of filing a proof of claim. And it lets everybody, especially the creditor on whose behalf you're filing it, know that a new claim has been filed. And you really just have to follow the rules with regard to 3004, the federal rule 3004, on how to file those claims on behalf of the debtor. Little bit of a change with regard to motions to determine secured status or valuation of collateral. We're not seeing these very often just because the real estate market's been so crazy that we're not seeing the opportunity to do a lot of strip-offs, but that ebbs and flows. So as it comes back, something to be aware of is that you now must include the legal description of the property. That includes the date of the deed of trust, the recording date, the county, book, and page or reception number of the recording. So it's a little bit more detail, and this is really put into the rule at the request of debtors counsel because we want that information in the order. It makes it so much easier to record it with the county, to give notice to the creditor that that lien has been voided, and to really help with a lot of the title issues we've been seeing with post-Chapter 13 strip-off cases. So again, we're not going to see that very often, but as that may potentially come back, just be aware that that's a requirement. There's also a requirement with regard to service under 9014 and 7004. Just make sure you're serving those correctly, addressed to a CEO or board member, someone like that, and sent according to those rules. Similarly, while you no longer have to file any motions to void or to value collateral on personal property, and that has been in our plan for some time, they do want the vehicle identification number. So you'll see that under 3012-1 subsection B2A, a requirement that you include a VIN number for any vehicle you're doing a cram down on. Here's our big one, 3015-1. There haven't been significant changes to the rule. A couple things we did that make the rule a little bit easier to use. The old rule had what I like to call the Judge Campbell provisions. Judge Campbell liked to run his confirmation schedule differently than the rest of the judges. So there were kind of duplicated provisions that addressed just how things operated in his chambers. Those have all been eliminated, so that's been really a helpful thing. Second is that there are a couple of changes with regard to filing objections to Chapter 13 plans. We've moved the deadline from 3 court days before the 341 meeting to 7 days, calendar days, remember, after the meeting of creditors. So a week after the meeting of creditors is when objections are due. The goal there was to hopefully avoid some objections by giving the Chapter 13 trustee an opportunity to inquire of the debtors at the meeting of creditors. There are some requirements in 3015-1 C5 and 6 about what has to be in an objection. I really like that there's some details here about what has to be in if there's an allegation of arrears. And also, any party filing an objection based on the debtor's expenses or current monthly income has to specify each expense item or calculation to which the objection is being raised. This is going to be a gotcha if the trustee's attorneys aren't being specific about the objections. The rule requires that those be delineated very specifically. And if they're not, I think you can say to the judge, look, there's not compliance with the requirements of 1315 or 3015-1. We'd like to have that objection struck. There's a little bit of a difference with regard to the timing on meet and confer, verification, and filing of the new status report. First, if there are no objections to your plan, you are a rock star. Congratulations. 10 days, no earlier than 10 days after the meeting of creditors, no later than 7 days before confirmation. So it's kind of a short little window there for filing your verification. If there are objections, your meet and confer obligation is 10 days prior to the confirmation hearing, and you need to file the new confirmation status report 7 days prior to the confirmation hearing. So that's a little bit longer deadline. It's a little bit shorter amount of time than the old deadline. Again, it was 3 days prior to confirmation, 3 court days prior to confirmation. The certificate and motion to determine notice was due. This is 7 days prior to the meeting, so that tends to be longer. I think the new confirmation status report is great. I largely had a big hand in drafting that, so of course I love it, but I really like that it kind of spells things out. It's really a check the box, so if this applies, check it. If it doesn't, leave it unchecked. I think there was a lot of confusion with the certificate and motion to determine notice about what do I include? Do I take this out if it doesn't apply? Do I leave it in? We've tried to eliminate some of that. We certainly tried to eliminate a lot of the repetition within that document. Judge McNamara was a very vocal advocate of making the change. He's looking for really solid, straightforward information. We've had lots of conversations on the listserv and at the CLEs about this, but use this as a way to communicate with the judge. These new judges, and I think our existing judges as well, want to hear what's happening in the case in a concise and straightforward way. Because we're not appearing every time at a confirmation hearing, they want to get some good information from you in writing about where things stand. Another point that I'm going to make here is, the judges have announced this 3 strikes you're out rule with regard to Chapter 13 plans, which means you can file an original plan and up to 2 amendments before they're going to contemplate dismissal of your case. So that's a pretty short window. 2 amended plans is, a pretty short little time frame to get things right. So what I'm going to encourage is that if, the rule allows under subsection E3 that you either have to file the plan contemporaneously with the status report or on the date indicated in the report. Knowing that we have these, restrictions on how many amended plans we can file, my new policy in my office is that we provide the documentation and information to the trustee along with a draft plan and or budget that adjusts makes whatever adjustments we think are appropriate. In my confirmation status reports, I'm indicating what exactly has been provided, when the documents were provided to the trustee, and a section that indicates that it is the debtor's, hope that the trustee will have an opportunity to provide feedback on the proposed changes, and that on or before the date of the confirmation hearing, and that debtor will file those documents the day after the confirmation hearing, or in the event the trustee needs additional time to review them at such later date as the court may find appropriate. And the reason I'm doing that is because I don't want to tie myself into a deadline or have to file a new plan, an amended plan, prior to it actually being something that could work. I'm really going to put a lot of pressure on the trustee's office that if you didn't like what I filed before, I want you to look at this and give me some feedback before I have to file it again. I can file 100 plans until we get it right, but if I'm limited to 2, I need their feedback prior to filing. So that's going to be the plan in my office. We have had some changes to the forms. I think a happy reduction in the number of forms that we have. So 3015-1 has 6 forms. The first is the plan, pretty obvious. The second is a notice of filing. There's just one. You don't have a million different notices, 1.6, 1.7, 1.8. It's just one notice. I know the question has come up, what if the judge wants language in there about, calling in for confirmation hearings? I have gone ahead and just made, as a form, a separate notice of filing for each courtroom. That way I can have the specific details of the courtroom letter, plus all of their call-in information, without having to reinvent the wheel every time. So if you haven't done that, just make a copy, there's only 5, and have that available so you can just use it as a template. The third is the verification of confirmable plan. Not much has changed there. The fourth is the confirmation status report. Of course, use the new form. I have had a couple of people ask, I really like the way that I did my form before. Do I have to change it? Yeah, absolutely. These are the forms that our judges, have approved and have asked for. And what I'll tell you with regard to all of these rules and all of the forms, the committee had a significant impact on changing some of these things, but it's really the court and the clerk's office that made the majority of the changes, that put the time and the hours in. Our judges were spending hours a week for the past probably 6 months working through these together, trying to find ways to slim them down, to make them workable. So a lot of effort and a lot of capital has been put into making these changes. So if in doubt, follow the new rule, use the new form. I did have another question that came up, and it's appropriate probably to talk about here. Do I have to change over to that weird black caption? There's no requirement as to a specific caption. I think if you can use that caption in the forms that the court has provided, they come in Word and PDF. Use it. I think if not, they're not going to be super restrictive about what the caption looks like. As long as it includes the information that's required by the federal rules, I think you're going to be fine. The fifth document in Chapter 13 practice is the notice of a continued 341 meeting. That practice hasn't really changed. It just gives you some information there. And the last one is the certificate to obtain discharge. The second page of that certificate to obtain discharge is the order, the post-confirmation order voiding the lien on any stripped off liens for mortgages or real estate property. So be aware of that as well. The next rule we're going to talk about is Rule 4001-4, which is the rule regarding continuation of the automatic stay or imposition of the stay. Keep in mind, if you have a client that had a case pending within the year prior to filing the current Chapter 13 case, you don't have an automatic stay for more than 30 days. So at the end of 30 days, it goes away. If your client has had 2 pending cases, the automatic stay doesn't exist as of the filing of the case, but you can request either extension of the stay or imposition of the stay. And 4001-4 talks about that. The one change here, it's nothing significant. It's still the same 30-day period, so you've got to move pretty quickly getting those filed. I always recommend having that ready to go when you file the case. But the big change that I'd like to point out is under A4. The judges are really getting to be a little bit more particular about what kind of supporting documentation you add to your motions or what kind of legal support or argument you have. A4 requires that you provide clear and convincing admissible evidence with regard to the good faith nature of this request. That could include a verification by the debtor or an affidavit as to the pertinent factual allegations, and if applicable, how you're rebutting the presumption of the prior case, of the later case not being filed in good faith. So just something to be aware of, that you want to keep that in mind. We're on to 4003-2. That's lien avoidance under section 522F. So these are judicial liens under 522F. Keep in mind that you've got this requirement again to provide the actual you've got to provide the transcript of judgment. But not only that, you've got to list the creditor in the pleading. Apparently, we've had some issues with really generic 522F motions being filed and then the specific information being added as an attachment. Make sure you're listing out that creditor's name in the filing. So just a note there on that one. 5005-1 is new. It's really a statement to the public and to anyone who's working under these rules that the official court record is the electronic version. So whatever is in the electronic file is what the court considers to be the official record of the case and of the docket. So keep that in mind. Couple more things with regard to 5005-4, that's about the electronic filing. Keep in mind that there has been a rule change here. Registration for CMECF constitutes consent to receive notice electronically via CMECF. So from now on, any attorney who files any document with the bankruptcy court has to register with CMECF, and it constitutes notice under CMECF as well, or consent to receive notice that way. You have an obligation under 5005-4A5 to hold on to original signatures for 2 years following the expiration of all time periods for appeals in your cases. Another note that is not in the rules, but it's of interest, the clerk's office has made a policy change with regard to payments on your ECF account. If you file a case or file a motion that requires additional payment, those payments are due by close of business. Failure to make payment by close of business on a case will result in freezing of your ECF account, and repeated violations could result in suspension of your account. So the trustee's office basic premise is that, hey, for a while you've kind of been able to float, and we're not going to allow that anymore. So be sure that if you file a case, you pay for the case the day that it's filed to avoid suspension or freezing of your account. I think one of the biggest changes that has happened in the rules, and it doesn't affect us very often, probably most often in Chapter 7 asset cases, is that the local bankruptcy rule 6004-1, sale of estate property, has had significant changes. The first thing I'll point out is that it's about, I want to say it's like 6 pages long. It's crazy. It's a really long rule. And really the thought process behind this is having a little bit more complicated sale procedure with a little bit better notices and things like that is a good attractor for Chapter 11, higher end Chapter 11 cases to be filed here. There are some provisions for small sales that may apply in most of our Chapter 7 cases, but it's one of those areas that if you're interested, definitely check out that rule. Another big change, and this certainly has the potential to impact our caseload more often, is a change to the discovery rules. So that's 7026 and -1 and -2. Basically what has happened is Judge Romero and Judge Brown were using their special discovery procedures, which is basically no written motions with regard to discovery. Short and simple, if you had a discovery dispute, you've tried to resolve the dispute, and if you couldn't, you ask for a hearing. The neat thing about the way that it works, and I think it really encourages litigants to be reasonable, is that not only are the attorneys required to attend the hearing, but their clients are required to be there as well. And Judge Romero talks about how frequently he's able to see settlement happen much quicker when the clients are present, because they don't want to see these kinds of disputes go forward. They're expensive, and these new discovery rules are really good about helping to resolve those disputes without a lot of litigation back and forth. So definitely look at those if you're doing any kind of litigation, and be aware that they're different. Let's see. There are new, not necessarily new rules, but I think a real good clarification in the rules for 7,055, 56, and 69. That's a default, failure to defend, summary judgment, and execution on judgments. So there's been some good clarification in those rules. So if you're using any of those processes through your practice, be sure that you take a look at those. There was a proposal when these rules were first published at the beginning of November to require all attorneys practicing in the District of Colorado Bankruptcy Court to be admitted as attorneys in Colorado. That proposed provision has changed. So 9010-1 is 1B, talks a little bit about admission. You do not have to be admitted to the Bar of Colorado. You do have to be admitted to the United States District Court for the District of Colorado. So anyone not aware of that change will want to take a look at that. If you thought you had to become a registered Colorado attorney, you don't any longer. However, there is an indication that the court can require that you associate with a Colorado attorney if you don't have an office here, and that's at the court's sole discretion. So there's not a pro hoc vice procedure as there was in the proposed rules, but there is a caveat that does allow the court, if it believes that you're not practicing in accordance with Colorado law or responsibly and you don't have a Colorado office, that it could require you to associate with a Colorado attorney. I think the big thing in 9010-1 is the scope of representation or the unbundling provisions, and I think there's a little bit of confusion about this. I think the rule is a tough one to write. So I went ahead and kind of just made some notes, and I'm going to go through those with you as well. So 9010-1C talks about the scope of representation in a bankruptcy case. The basic here is that you cannot limit the scope of your employment in your fee agreement. You can provide for additional fees for services that are in excess of what are called the basic services, and those are defined in this rule. But you can't say, I will not do XXX. And I'll kind of go through that a little bit more as we get into the rule. An attorney, it basically says, you may not circumvent this rule by limiting services in your client engagement letter or in your disclosures that are filed with the court. There is limited unbundling. Of course, you don't have to do adversary proceedings. That's a pretty easy one. Second would be ethical limitations. If you can't uphold your duties ethically, or you've got a problem with 9011, you can advise the court that you can't respond on behalf of the client due to those ethical issues. That would be using the notice of advisement form, which is 9010-1.1 is the notice of advisement. Interesting thing is that the notice of advisement is talked about in depth and just a little bit further back in the rules, so we're going to get back to that. But if you have an ethical conflict that prevents you from assisting the client with something, you just need to let the court know about that. The third reason that you can unbundle your services would be for non-payment of fees. Now, the rule is very specific. If you are asking for a fee and not being paid, the only recourse is to withdraw from the case. The rule is very specific and indicates that an attorney for the debtor may not withdraw. A withdrawal will not be granted prior to completion of the basic services. So let's kind of go through what those are. Basic services include meeting with the debtor, advising the debtor, and analyzing the needs of the case. The second is preparing a complete filing packet as required under the Federal Rules of Bankruptcy Procedure 1007 and any necessary amendments to it. The third is attending the meeting of creditors. and any continued meetings of creditors. The fourth is advising and assisting the debtor with the trustee requests for turnover and any audit requests received from the U.S. Trustee's Office. The fifth is advising the debtor regarding reaffirmation agreements. And F is, I think, really important. In Chapter 13 proceedings, a debtor's attorney may not exclude from his or her representation the basic services, which we talked about, those 5 things up at the top, or any necessary service. That's defined here as all services necessary to represent the interests of the debtor in a case. So you can't unbundle anything in a Chapter 13 case, whether such services are required before or after confirmation, except as set forth in 9010-1C2, which is the discussion about the ethical limitations in the notice of advisement. Nothing in the rule, however, prohibits an attorney from charging debtors additional fees for services not contemplated in the original agreement between the debtor and the debtor's attorney. So the way I kind of broke it down was you can charge an additional fee for all the necessary services you want. And if those don't get paid, you can withdraw. The key is under 9010-1 C2C little 2I. While a motion to withdraw is pending, you must continue to perform all of the necessary services. So you can't, and I think this is really well spoken in the comment, the rule prohibits charging a set fee for the basic services and then refusing to provide additional services as they become necessary unless the debtor agrees to pay the additional amount and also remaining attorney of record. So if you ask for payment on additional services and you don't get paid, your only recourse is to withdraw. And until your withdrawal motion is granted, you have a continuing obligation to provide every necessary service to the client. I think that's pretty basic. You either have to, let's move on to the notice of advisement. We talked a little bit about the ethical issue. If you can't ethically file a response, the client says, hey, you let your client know you got a motion to dismiss or a motion for relief from stay on your house because you haven't been making the house payment. And they say, yeah, you're right, I haven't been making the house payment, but I really need to stay here, so I want you to file something anyway. Well, you can't ethically do that. It would be a violation of 9011. You have knowledge that the debtor has not been making the payment. Unless you can come up with a novel or other way to defend it, you would have a problem filing that motion. In that case, you file a notice of advisement. If the debtor says, you know what, you're right, I haven't been making the payments, I'm going to let the house go, you're not going to respond, you still have to file a notice of advisement. So in the note, I think it's a really helpful note that basically says, no matter what, you have to file a notice of advisement. Basically it says, filing a notice of advisement is permitted when the attorney cannot advance a position due to the ethical constraints, or the debtor has advised the attorney that they don't wish to oppose the motion. So you really have 2 options anytime a motion comes in for your debtor. File a response or file a notice of advisement. And that is the local bankruptcy form 9010-1.1. There is an indication that if you fail to file that notice of advisement, the court can act sua sponte and issue monetary or other sanctions against the attorney for violation of this provision, including an award of reasonable attorney's fees to the other side. The judges are very, very strict about this, and I just want you to be on notice. The last little thing that I'm going to mention about 9010-1 is subsection 3, which talks about ghostwriting and serving as a BPP or a bankruptcy petition preparer. You may not do either of these things as an attorney. So if you're an attorney and you've got someone that you really want to help, you still have to enter an appearance. You still have to put your name on the record. No ghostwriting, no acting as a BPP. Hopefully that's common sense, but you never know. 9010-4 has the withdrawal requirements. Those are largely unchanged. What is changed in 9010-4, which I love, is subsection B. and it talks about substitution of attorney. You know, we've all been in that situation where, hey, I'm going to have so-and-so take over the case because I either can't or don't want to continue working on it. The old requirements under the rule were that you basically had to file your own motion to withdraw and have that person enter their appearance. The judges recognize that that's really pretty excessive. If you've got someone who's willing to take over responsibility for the case, having them just sign off and you sign off is a good way to do it. You'll note that there are two different forms. There's Form 4.1 and Form 4.2. So if the attorney that you're substituting in for is available to sign, you can file 4.1. If they are unavailable and the client can't get in touch with them, you can't get in touch with them, you can sign 4.2 by yourself, and that will substitute them out as well. Last couple things, remember 9011-4 requires that you include your name, address, phone number, and email address on your pleadings along with your bar number. So be sure you're getting that in all of your pleadings. You no longer have to include a fax number. You have a presumptive response time in all motions practice. It's 14 days. That's under 9013-1. Subsection A5, and your certificate of non-contested matter has had a shortened time frame. These are kind of some miscellaneous things here at the end. So it used to be you had to wait 3 days after the deadline to allow for mailing. That's been reduced. The clerk's office has become more efficient at filing mailed-in responses, plus the change that requires all attorneys to file things via ECF. I think we're going to see a nice change there. So you just have to wait 2 days to file your certificate of non-contested matter. Sometimes that can be really helpful, especially when you're dealing with fee applications or other things like that. So certificates of non-contested matter are 2 days. Let's see. Last thing, there's now the default deadline on witness and exhibit list, 9070. They have to be filed no later than 5 days prior to the hearing. The only reasonable exception to that is under 4001-1. That's on motions for relief from stay. Remember, your witness and exhibit lists have to be exchanged 24 hours prior to the preliminary hearing. So be sure that you're putting that in there as well. That's about all I have. I hope that if you have questions, concerns, comments about the rules and the changes, that you'll feel free to email me. Feel free to post it on the Debtors Council listserv. Certainly we want this community to participate, to understand, to be helpful and helped by the rules and the new forms. I know it's always a learning curve when you start, and I'm hoping that just a little bit of information today will provide you the extra information that you need to get your practice up to speed. As it's December when the rules change, I hope that everyone has a peaceful and happy holiday, and I thank you all for your communication, your participation, and your support. Thanks and have a great day.